Madam Speaker, I rise today in support of H.R. 3195, the Americans with Disabilities Act Amendment Act of 2008. Since 1990, Americans with Disabilities Act has made it possible for millions of productive, hard-working Americans to participate in our nation's economy. Among other rights, the law guaranteed that workers with disabilities would be judged on their merits, not on their employers' prejudices. But since the ADA's enactment, several Supreme Court rulings have dramatically reduced the number of workers with disabilities who are protected from discrimination under the law. Workers with diabetes, cancer, epilepsy, the very workers that the Americans with Disabilities Act was intended to protect, can be legally fired or passed over for promotion just because of their disability. In January, the Education and Labor Committee heard testimony from Kerry McClure. Because he was diagnosed with muscular dystrophy at age 15, Kerry had been working as an electrician for more than 20 years. Like so many other Americans with disabilities, Kerry was able to find his way to successfully perform his job and all of life's daily tasks despite his disability. Kerry received an initial job offer from General Motors pending a physical. During the physical, the doctor asked Kerry to hold his arms above his head. Kerry could not. The doctor asked how he would perform his job if he required reaching over his head. Kerry gave a common-sense answer. He would use a ladder. When General Motors learned that Kerry had a disability, it rescinded the job offer. Kerry challenged General Motors' decision because he thought the Americans with Disabilities Act would protect him. He was wrong. The court ruled that since Kerry had adapted to his condition by modifying the way he performed everyday tasks like washing his hair, he was not disabled and therefore was not protected by the Americans with Disabilities Act. Because of the Supreme Court rulings, Kerry and many others are now caught in an illegal catch-22. The court has determined that individuals whose disabilities do not prevent or severely restrict major life activities and those who mitigate their impairments through means such as hearing aids, medications, should not be considered as disabled. In other words, an employer could fire or refuse to hire a fully qualified worker simply on the basis of his or her disability, while contending in court that the worker was not disabled enough to qualify for protection under the law. H.R. 3195, the legislation before us today, a bipartisan legislation, was introduced by Majority Leader Hoyer and Congressman Jim Sensenbrenner that remedies this problem. The bill reverses the flawed court decision and restores the original congressional intent of the Americans with Disabilities Act. H.R. 3195 clarifies the definition of a disability, ensuring that anyone with a physical or mental impairment that materially restricts a major life activity is covered under ADA. In 2004, workers with disabilities lost 97% of the employment cases that went to trial. There has been no balance in the courts, putting workers at a distinct disadvantage. Too often these cases have turned solely on the question of whether someone is an individual with a disability. Too rarely courts have considered the merits of the discrimination claim itself. H.R. 3195 stops the erosion of civil rights protections for people with disabilities while maintaining a reasonable solution supported by the business community. The U.S. Chamber of Commerce states that H.R. 3195 represents a balanced approach to ensure appropriate coverage under ADA. The Human Resources Policy Association whose members employ 12% of the U.S. private sector workforce also supports the bill. The organization says that the ADA amendment would maintain the functionality of the workplace while providing important protections to individuals with disabilities. H.R. 3195 makes it clear that the Americans with Disabilities Act protects anyone who faces discrimination on the basis of disability, and the Congress intended the law to be constructed broadly. Many of our nation's injured veterans returning from the battlefield will also need the protections guaranteed by the ADA. When injured soldiers return to civilian life, whether they go back to a job or to school, they should not be subject to discrimination. This legislation will ensure that they will not have to fight another battle, this time for their economic livelihood. The Supreme Court rulings have also reduced protections for students with disabilities. The ADA amendments ensure that students with physical and mental impairments will be free from discrimination and will have access to the accommodations and the modifications they need to successfully pursue an education. This legislation has broad support. Democrats and Republicans, business and advocates for individuals with disabilities. I'm pleased that we were able to work together to get to this point. And it's time to restore the original intent of the ADA and to ensure that tens of millions of Americans with disabilities who want to work and to attend school and to participate in our communities will have the chances to do so. And I urge my colleagues to support this legislation. And again, I would like to give special thanks to Majority Leader Steny Hoyer of Maryland and to Representative Jim Sensenbrenner of Wisconsin for their outstanding efforts on behalf of the members of this House during these negotiations to bring those negotiations between the civil rights community, the disabilities community, and the employer community to a successful conclusion, which is embodied in this legislation today, and I reserve the balance of my time.